As we continue with part two, assessing expert testimony on cognitive impairment at trial, we're fortunate to have with us three distinguished speakers. Their full biographies are included in your materials. So in the interest of time, I'll keep these intros brief. Dr. Sarah Mourra is a double board certified psychiatrist specializing in adult and geriatric psychiatry. She completed her training at UC Irvine, Yale, and UCLA, where she now serves as assistant professor of psychiatry at the UCLA David Geffen School of Medicine. Dr. Mourra is widely recognized for her work in geriatric forensic psychiatry, including evaluations involving testamentary capacity, undue influence, elder abuse, and conservatorships. Dr. David Trader is one of California's leading integrative adult and geriatric psychiatrists. A graduate of Stanford and Duke University, he completed his psychiatric residency and geriatric fellowship at UCLA and is board certified in both general and geriatric psychiatry. Dr. Trader is a nationally recognized expert on mental capacity and undue influence and has testified in more than 100 trials. And Judge David Cowan is the sole LA Superior Court judge assigned to long cause probate trials. He's served as supervising judge of the probate, mental health, and civil divisions, and has taught wills and trusts at both UCLA and Loyola Law Schools. Prior to joining the bench in 2005, Judge Cowan practiced business litigation for over 17 years. Now let's get started.
Thank you, Jennifer. Good afternoon, everybody. Appreciate your joining us this afternoon on this very interesting topic. This is, as you know, part two of this little series. Last time we spoke about the doctors, and thank you both, Dr. Trader and Dr. Mourra, for being here. Spoke about some basics and foundations relating to capacity and medical terminology and how they provide opinions relating to capacity. What we're going to do this afternoon is move on from that and discuss how this plays out in the courtroom. If you can keep going, Suzanne, keep going to the next one. Next page, please. There we go. So this is what we're going to be doing this afternoon. We're going to really break this down into about 5 areas: retention of experts, the foundation for an expert opinion, the types of opinions, the limits to their opinions, and then break down how that applies in the undue influence context, having spent some of the last session on the straight capacity issues. And then finally, if we have time, the doctors will have some final comments. Before we get started, I wanted to bring to your attention the attached materials. There is three of those, each of which is really worth reviewing in your own time. First is an excellent article, and it's short, very readable, called Assessing Undue Influence by Dr. Plotkin, Dr. Spar, and attorney Howard Horwitz, that in 10 pages really goes into the basics of what a mental health professional can testify concerning in a legal context. So it's really worth reading, very short. If you have more, want to get into this in greater depth, there is an article from the San Francisco Superior Court and a foundation that's a little bit, it was actually published right before the statute was created, defining undue influence, but really goes into over 150 pages relating to how that statute almost was drafted. That's my bleed on it. Dr. Trader may have some more information about that, but it's a really, really comprehensive, thorough looking at both case examples as well as the thinking behind why the statute is what it is. And then finally, we have an unpublished decision I'm going to talk about from the last couple of months that has an excellent analysis of how this area fits in with the evidence code and things you need to think about in terms of what records, what testimony can be admissible in this area. So that's there for you to review as well. So with that introduction, let's go, Suzanne, to the next slide, please. Okay, so retaining an expert. One thing that I never get to do as a bench officer is know how an expert is retained. I'm not part of that process, obviously. So I thought that, and people, perhaps lawyers who've had less experience in this don't know the procedures about what kind of conversations can we have initially with an expert. Are we going to then, is that going to then be subject to deposition when the expert is deposition is taken? So what can I safely say, not say, and I don't want to put too many ideas into these experts' heads, and then their opinions be somehow compromised from the get-go. So I'm going to ask both of you, maybe start with you, Dr. Trader. Um, what is the difference from your perspective as between a consulting and a designated expert, and how does that are you consulted, and then what happens in terms of your designation?
Thank you, Judge Cowan. I think the difference that, as I look at it, between a consulting and a designated expert, when I'm first asked to review a case, or I'm called by an attorney, and the foundation is laid, and let me just say and I think Dr. Moore and I have both experienced, and the attorneys will have to decide how much information they give and what's biased or not, but I think both of us can probably sort of see through the weeds. We obviously know what the attorney would like us to say, but when we're consulting, basically, usually we review materials that are sent to us, and after reviewing those materials, whether it's medical records, depositions, pleadings, and so forth, we're asked to provide some initial thoughts. And certainly if those initial thoughts agree with the requesting attorney, fine. Then we may be formally designated to testify at deposition or trial. But let's assume, our opinion is not what the attorney wants to hear. If we remain as consulting experts, usually that information doesn't go any farther. It may, but usually it doesn't.
So what do you need to have done to give that initial opinion as a consultant?
Is the same information, whatever information the attorney provides or has, and it may be the same information as if I'm designated or to be designated as an expert. So whatever information is provided, that information is reviewed, and then the opinion is expressed. As an expert, I'll express that opinion back to the attorney, and they can say, "Yeah, okay, we agree and can work with you," or "Thank you for your service."
Dr. Mourra, are there cases you turned down because for different reasons?
Yes. So, I mean, there's definitely cases that I've turned down. I mean, obviously, the most, clear reason that I would turn down a case is if there's an obvious conflict of interest. So, that's part of where in the very beginning with that initial phone call, I ask for, before we start talking about anything, a list of the involved parties to make sure there's no conflict. So that's usually the number one reason that I would decline to serve in relation to a case. There's also situations where, I really can't support the position that the attorney is advocating. And I have to be really clear about that. And, oftentimes it involves returning the portion of the retainer payment that was related to writing a report or creating a declaration. Because again, I really can't support what they're asking. It's interesting. Sometimes they use us to consult, like we look at the data and we can say to them, there's not really a case for X, Y, and Z, but with, this particular issue you're looking at, there is some data to support that. And so they may narrow, what they're doing in consultation with us based on what's there and what isn't, in which case we may be designated, but with a more narrow scope in terms of what they're looking at. So there's different ways that this, plays out, but in terms of declining to serve, that does happen. And, we sort of decide that we're not going to move forward.
Dr. Trader, what about the lawyer who comes to you and she says, my deadline to designate is tomorrow. How do you deal with that? Probably common situation.
I don't like to deal with it, but let's say if that person is in a bind, I will usually say, if I choose to do it, and if there's sufficient time between the designation and deposition or trial, then I'll say, okay, send me the information. However, you must know, I may not be able to support your position. So quite often I will decline just because of timing. Because usually when they ask, we have to designate tomorrow, usually there's a deposition that's soon to follow and a trial soon to follow. And my schedule may not allow. But if it does, then the attorney just has to know, I may not be able to support your position.
Dr. Mourra?
I would say the same.
Okay, so let's talk about the scope of an assignment. Sometimes I'll see, listen, one of you, or both of you are in my courtroom quite a bit, will say, or somebody else will come in and say, we have no opinion about capacity, but we have an opinion about undue influence. What is a bench officer? What inference should be drawn from that, if any, or is it inappropriate to draw any inferences? Those opinions sometimes stand out. Okay, why is this doctor not giving an opinion about capacity, but she is giving an opinion about undue influence? How do you address that issue, if at all?
I'll yield, Dr. Moore.
Sure. I always tell, forensic psychiatrists that I lecture to, et cetera, our work is not going to be any better than the specificity of the question we are asked. So usually, in terms of the scope of what I'm asked to do, I'm really relying on the attorney to give me a sense of what what position they are taking. So, i.e., is capacity at issue here, or have they looked at the documents and the things that are available and determine that that's not an argument that they can even make. And so they're working on focusing in on susceptibility to undue influence. So sometimes that's very clear from the get-go. They just want me to look at this particular part of it. Sometimes they ask me to look at the wrong type of capacity in relation to the document, and that can backfire on them in court. But I'm usually not necessarily the one dictating what my scope should be. However, sometimes I'll do an initial review and say, I'm not seeing a lot of data relating to capacity. I am seeing more data relating to undue influence, and then they will sort of work on their position in relation to what they feel is kind of the stronger argument. And that's where my scope may get a little more narrowed, but I've certainly had people ask me, do you have thoughts about capacity? You reviewed all of this. You were asked to look specifically at undue influence, but you must have some thoughts about capacity, in which case, if there are things I looked at that are relevant to that, I will say that. But so that's typically how I look at the scope.
Dr. Trader, can you give an opinion about undue influence with credibility if you don't assess capacity?
Well, certainly capacity is going to be specific to whatever issue, but in my opinion, the answer is yes, because undue influence, at least from a medical expert's position, has more to do with the sort of the vulnerability features, and usually it's the mental health aspects of a person. So we can assess assuming haven't seen that person, didn't interview that person, and we're relying more on medical records. Still, we can assess as best we can through medical records the vulnerability features, whether it's age, dependency factors, what the activities of daily living or lack thereof. So we can do that assessment necessarily, and it may not have anything to do with capacity.
Okay. Let's talk about written versus oral reports. Um, does that and which side you might be giving an opinion on behalf of? Let's say you represent, or not represent, thinking you're a lawyer, but let's say that the lawyer who you're working for, her position is to challenge the instrument in question. Uh, do you think that what's the thinking in terms of providing a written report versus providing an oral report, or is that consideration at all?
I'll say it depends upon time. First of all, it's a consideration. But let's say sometimes attorneys do not want a written report. There's more information possibly to attack versus an oral report. But again, after reviewing the materials provided, we'll give uh, an oral report. You know, here are the thoughts, here what we can support, maybe not what we can support, as Dr. Mourra said. Sometimes, and going back to your question, Judge Cowan, about undue influence versus capacity, I think in some situations, if an expert, if the allegations are capacity and undue influence, an expert only sort of gives one position, chances are you can say that, you know, perhaps they're on issues of capacity. Sometimes even the attorneys, when they get us the information, will say, we don't think there's much in capacity. What do you think? So, but having said that, the written report, and I know Dr. Mourra can address this one. Sometimes it helps organize thoughts and before we get to a deposition or trial.
Dr. Mourra?
So I've definitely had, we rely on the attorney to let us know whether they would like a written report. So it's not necessarily me making the decision about whether to do it or not. Sometimes it's related to cost concerns. Sometimes it's related to, because that's kind of the most time intensive part of what we do. Sometimes it's very much related to what Dr. Trader said. They don't want little things that can be picked out and used kind of or turned around on, our testimony. So they like to, some attorneys like to not have a report, whereas some obviously do. Certainly one of the advantages is, when I'm doing a retrospective review, there's multiple citations that I'm using throughout the different records, and I'm able to retain those references a lot better when I'm testifying, when I've written a report, because it's almost like it's all solidified and organized more effectively. But there's certainly pros and cons, obviously.
What's a red flag in terms of input from counsel that will make it impossible for you to do your job?
Wow. Other than time?
Other than time.
Definitely leaving out key things, like really, really key sort of events or occurrences that, would be very important for me to know, but are not contained in the records I received. And learning that much later on in the case, I like to know, the important information really up front. Dr. Trader, I don't know if you've had that experience where kind of bombshells get dropped on you a little later.
Sure. And let me add to that also. I think one of the issues that for attorneys, in addition to leaving out information, is restricting as an expert what we can do. Or say, we would like for you to, review this material, but not this, or interview this person and not that person. And I think it's rare, but I think those restrictions, because quite often in reviewing materials, as an expert, we may go back to the attorney and say, well, can we have additional information? So I think that restriction, to me, is the biggest red flag. It usually doesn't have to do with, sometimes it has to do with money, but a lot of times it just has to do with whatever that attorney's thing is.
Yeah.
All right, let's go to the next page. Oh, sorry, go ahead, Dr. Mourra.
Oh, I was just going to say, a major red flag is, let's say the individual that is on the side that I'm with has had multiple previous litigation related to estate plan changes, that would be also, that's happened before and was not shared up front. That's another, certainly a red flag that I would be thinking about.
All right. So let's go next to Suzanne to the next slide, please. Thank you. So now let's talk about foundation for your opinions. So the one thing that I always feel is, it's kind of going to the bottom bullet point here to start with. How can you even review those thousands of pages of medical records? It doesn't seem, people will sit there and say, "Oh yeah, I read, all of these records," and I'm thinking to myself, that can't be true. Um, so how do you go about doing that, and how much confidence should a court have in that when you say it? I mean, Dr. Mourra?
I think everybody's technique is different. I've certainly read depositions from other experts saying that they did a word search, or they did, they just searched for certain words and that was their review. For me, again, everybody has their own way of doing it. But for me, if I do it that way, I feel like I would miss so much because we're not just looking for keywords like diagnoses, like dementia, cognitive impairment, delirium. Those are important. But what's really important are these on the ground observations. So and so is kicking the sheets off the bed, saying he's in a pirate ship right now, on the day of signing, or things like that that are really key. It's these observations that can't really be found in that way. And then also handwriting. So, old physicians that still use like handwriting within hospital notes, that still exists. And you can't really pick up on that. So I do go through every single page. I'm really good at it where it's like a second now where I can look and just keep going. I'm not fully reading everything on that page, but I'm giving each page a glance to see if there are things that are popping out, because little PT notes, little nursing notes, they'll have these Easter eggs sometimes that are not necessarily searchable. And so I do think laying eyes on all the records are really helpful. Also, I don't like to be taken by surprise of, oh, did you see this? And I have not. So.
Okay, Dr. Trader.
Yeah, I would agree with what Dr. Mourra said. I think in our preparation, she brought up a good point. We can look at as a medical expert, we can look at medical records probably faster, of course, than non-physicians, just as attorneys and so forth can probably look at depositions and sort of other pleadings better than we can. But there are certain, I think I can say for both of us, and we said this, in our preparation, is that we generally look through almost all of the medical records. It depends. Usually, if there's a point in time, I may not look so far after that act. It depends upon how far in advance. So if the act occurred in 2022, I may not look in 2015, and I may not look in 2026, but usually around there. So and then there are certain parts of medical records that we can scan through very quickly, like electrocardiogram reports, cardiac reports that are pages and pages and pages. Of course, that's not necessary. But I think for both of us, we probably look through most of the medical records. I think you have to look at the individual experts to decide how credible they might be in doing so.
Have you either of you used artificial intelligence to go through medical records and keep the bill down?
I would say not to keep the bill down. I've tried, but my experience in AI is it doesn't always work, and it doesn't capture all the words. I can put in a word to search and it doesn't come up. So, or try to do a summary and it doesn't come up. And usually these records can be 500,000 of pages, and AI doesn't do a good job, or at least the summary doesn't do a good job in that. So for me, AI for medical records doesn't work very well.
Dr. Mourra?
Yeah, so I have not done that. I have been involved in a case a couple months ago where the attorney actually had done a preliminary AI evaluation of the records, but it didn't seem to yield a whole lot that was kind of the detailed stuff that we look for. I also have read that there are concerns regarding protected medical information being uploaded into these kind of clouds, right? There's definitely designations around. I know AI itself has designations around or rules around, loading protected health information into let's say Claude or Chat GPT. So I've kind of avoided it for a multitude of reasons. Also, given the fact that many of our documents are like 20,000 pages, and I don't pay for the extra membership that allows for reading that kind of volume. So I have not found it to be really a key part of this work. I imagine that may evolve.
So following up, Dr. Moore, on a point you made a minute ago about um, the Easter eggs and whether, as it were, and going to our second bottom bullet point here about medical assistant or notes of nurses versus physician notes. Um, which ones have the bunny inside, as it were? Which ones, in your experience, sometimes can provide that valuable information?
So it really depends. It depends on the person. So you could have a medical assistant who's really compulsive about documenting every little thing the patient said to them and all their complaints, and they happen to have a conversation about their whole family together. And you could have others who are less detail oriented. So I do find though that physician notes are a lot more geared towards kind of checking the boxes for insurance billing, whereas you tend to find with nursing notes, with physical therapist notes, there's a lot more detailed observations about the individual and what they are or are not able to do, what they're saying in the moment. I think I've brought up this example a number of times. I was involved in a case, it was like 30,000 pages of records. I was going through them late at night and I came across this tiny nursing note, very tiny font that basically said, watched niece come visit patient. Patient was unconscious, unawake, not awake. Niece grabbed patient's hand, put pen in hand, and had her sign papers. And the witnesses in the case were documented by the nurse as two men that stood outside. The nurse documented calling security and escorting them to leave, but there was nothing else written about this event other than this tiny little nursing note. And that was really the key to the case. So, because that happened, obviously, that was the date of the signing. So, it really depends, but I do think that these, kind of paraprofessionals are very, very key. They're very important. Social workers, medical assistants, nurses, physical therapists, occupational therapists. They often are giving a lot of details that are very helpful in what we're trying to do.
Dr. Trainer?
And I would agree with that, and add that quite often physicians are on time, or at least are on time restraints, or they are very hurried and have to see multiple patients, whereas nurses, other allied health professionals, physical therapists, occupational therapists, or in a nursing setting, sort of the nursing assistants usually have more time to document, and that's where you'll find the juicy part. Usually the descriptions of a person's functioning is not necessarily in a physician note, but maybe in a nursing note or other allied health professional. The other part is that in many of these notes, especially physicians' notes, we find there's some cutting and pasting. So you go from one note to and it's the same thing, and maybe there's a little blurb somewhere about the assessment for that day. But the bunny, as you call it, is I think I often find in notes other than physician's notes.
So you beat me to my next bullet point, the one above. You taught me this phrase when we were preparing called chart law, and you told me about that in response to my question and frustration about trying to figure out reading these records in a trial, whether or not there was cutting and pasting. And you told me basically there is. So can you tell the audience about, how carefully do we have to read these seemingly some record on March 15th. Is it really an observation on March 15th, or was it an observation from November 26th?
And I'm going to say, I think that was Dr. Mourra who said that, so
Okay.
she should describe it.
Yes.
All right.
So, we have this term chart lore, which is basically where one random person on a random visit sort of writes something down and then, or will stick a diagnosis in, and then it just gets copy and pasted all through the next, the notes that follow without necessarily being true or established or validated. So that can be problematic. I think in terms of cutting and pasting, we're always looking for exact sort of unusual phrasing that is repeated throughout, from one note to the next note to the next note. You can usually, assume that if it's fairly unusual phrasing with like a couple details and it's cut and paste, it's sort of in the exact same way in the next note for the next 6 months, that's probably something that just got moved, cut and pasted and moved forward. So it is really tricky. And we deal with this all the time as physicians of trying to figure out, what was this person's functioning actually on this date, or is this just kind of a cut and pasted note? And how can we validate what's actually written here? So it is a very real problem in our field as well as within this area.
There's also a problem with the chart lore and notes moving forward, is that there is an assumption that the original note is correct. So, and it may be, and it may not be, but that the words are carried forth. If they throw out the word, this 83-year-old man with dementia, it gets carried forward, and that person may or may not have dementia, but that term goes forward. So I think when one sees the same wording, going from note to note, you can pretty much assume that that note didn't occur, or at least the initial part of it did not occur on the date that you're reading.
So I had a matter where where the medical record indicated, quote, dementia, and then further analysis by an expert indicated that was really only there for code purposes for insurance and billing, and the rest of the records actually did not support that conclusion. How are we meant to sift through things that are there for insurance or coding purposes?
I would say, let me just say, you may not know that it's there for insurance or coding purposes, but let's assume that it isn't. It may be that clinician believed at one point this person had dementia. That person may or may not be correct, but you're right. It can occur for insurance purposes, but that may not be the case. I think this is where you have to go through other notes and other descriptions of the person's functioning, and especially with, as we said before, allied health professionals.
I would also add, a lot of times a diagnosis is given for insurance purposes very much in relation to a very expensive test or a very expensive medication. So when I see the diagnosis on the imaging report or on the imaging order, that I don't value that as much as I'd value that diagnosis within the physician's sort of assessment and plan, talking about what they're seeing. Because yes, to get an FDG PET or to get some of these more expensive tests, to get some expensive medications, having the indication of that diagnosis is sometimes what's needed for coverage. So I do make a distinction between those two types of notes that we might see.
And if I can throw in one more, I agree. If I can throw in one more thing, especially in rehabilitation centers within a hospital or outside of a hospital, quite often let's say for therapy, the clinician has to make the person appear more impaired than they really are, again, for insurance purposes.
But let's say we've got somebody who died and they went to their primary physician was at Cedars. But then they went to see had some testing done at a different doctor's office. Are the CEDA's records, for example, going to have all of these different doctors that may be in their network, or how does that play out in terms of, do we have the right records, or are we going to need to do it? Is the attorney going to need to subpoena, Dr. Jones's records and Dr. Smith's records, or how does that work? Or does it depend on, is it they're at Kaiser, the different hospital chains? I mean, how does that work?
So there are situations where, all of the providers are encased within the same hospital system, in which case, we are able to access all the records. However, patients, they're, sometimes they have like a concierge person over here that has no connection to Kaiser because they felt that Kaiser wasn't addressing their mental health the way that they wanted it to be. And so, yes, absolutely. There needs to be, first of all, we have to know that they saw this outside person. And then second of all, the attorneys, have to be able to obtain those records because people go all over the place for their medical care. It can often be very fragmented, especially if it's not somebody that's just Kaiser all the way or UCLA all the way, So a lot of times what I'm doing for the attorney is picking up in the, let's say, Kaiser records, patient has outside psychiatrist, saw them on this date, this is their name, which then I will say to the attorney, actually, it looks like there's some really important records that we do not have because it's outside this system. Can you get those for me? So absolutely, the more records, the better, especially as they relate to mental health and cognition, which sometimes can be private people in the community.
Dr. Trader, I had a matter once where we got thousands of pages of different hospital records. And then during trial, somebody said, well, and this matter is now concluded, well, this person had a primary physician. We have no records from the primary physician. To what extent can we, is reliance on hospital records, which may deal with an acute issue, as opposed to reliance on the primary physician's records that may deal with, as I understand the term, more chronic issues or vice versa?
Sure. I'll make a general statement that usually the records from a primary physician are more comprehensive, give background information. The primary physician knows the patient much better. However, where they might not apply as much, let's say the act in question occurs either around the hospitalization or during the hospitalization, and that person hasn't seen the primary care physician, then those hospital records might be more important. But one should also look at the primary physician's records because let's say during the hospitalization, the person's there because they're usually they're sick other than just surgery. And so we have to be careful. We talked before about these terms, confusional state or delirium or whatever. So it's a nice to get a person's baseline, which is usually in the primary physician's records as opposed to the hospital records.
Dr. Mourra, anything you want to add on that?
Just that, we're in the business here of trying to put together a picture and a story that is coherent. And if you only get chapters of the story that are the worst time of your life, right? How many of us have gone to the hospital? You're usually in the worst shape, that you can ever be in when you're presenting to the hospital or the ER. When those are the only snapshots that we have, it's an incomplete story. So I think absolutely what Dr. Trader said, getting that primary care doctor notes and baseline, a better sense of like the baseline and what is normal for this person.
All right, let's turn to the next page, Suzanne, please, and talk about types of opinions. So one of my primary questions here for both of you is that when we're talking about the sliding scale for contractual capacity, and we have, as we can see in the second to last bullet point, that the trust has issues relating to taxes, provisions for subtrusts, has an interorum no contest clause or other, highly legalistic type issues, which, sometimes lawyers have a hard time understanding, let alone sometimes, somebody who may be in their 80s or 90s. How do you, as part of dealing with their understanding of these? How do you assess these different provisions, and how does that play out in some of speaking generally about when you're giving opinions relating to contractual capacity?
Sure. It obviously has to do, if we go by the probate code, with a person's ability to understand, communicate, rights, duties, responsibilities, understand and appreciate, I should say. So part of that assessment goes with the overall, what I call interview portion itself, apart from formal mental status testing, all that's important. But to get I like to get a person's spontaneous understanding of the situation. However, many people don't have that spontaneous understanding. So it really goes to, in assessing that person's overall mental functioning, do they have the ability to understand? And let's say if they don't understand, sometimes it's necessary, or if there are some questions, sometimes it's necessary to explain it. And often I will come back maybe in the latter part of the interview or examination and ask that person to explain it. So if someone can explain in general the situation and provide reasoning. So higher level cognitive functioning, and we talked about this before, involves executive functioning, planning, reasoning, organizing, judgment, decision making. And to the extent that a person can reason through the process, that gives a pretty good idea that they have the ability to make decisions on a contractual level.
Dr. Mourra?
So, I think in terms of this issue of like assessing the level of difficulty, ability to understand for a living person that we're speaking to, having the background information from the attorney about what exactly they're planning to do in front of me so I can sort of reference that is really important. And then like Dr. Trader said, like having them be able to articulate it spontaneously. If they're not able to, trying to understand, well, I heard that you're trying to do something relating to X. Like, does that sound familiar? And then sometimes that will cue them, oh, yes, actually, I'm going to do X, Y, and Z, and the reason is X, Y, and Z. I think it's when we get into the issue of ability to understand, something to keep in mind too is that we may have individuals we are assessing who have communication difficulties. It doesn't mean they don't understand. They're just having, an aphasia or a stroke. I once had to conduct an entire interview relating to this kind of thing in multiple choice questions. It took like 3 hours. But I found that the individual did actually understand, but they were, they needed a different way of being able to communicate that information. So it is very complicated. And I think this is why our evaluations are so long sometimes. But I think part of it is just being able to have an understanding myself and then being able to engage them in a discussion about it.
How big a
And,
gulf is that between? Go ahead, Dr. Trader.
no, I was just going to briefly add, in retrospective reviews, obviously it's much more difficult. And our ability as experts to provide an opinion on, especially on contractual capacity, is only as good as the information we receive from whatever sources.
In terms of in a retrospective perspective, how big a gulf is there between testamentary and contractual capacity? I mean, you all know the factors to think about, but as a practical matter, I mean, is it if somebody does have testamentary capacity, but maybe does not have contractual capacity, how difficult is that to draw the line between those? To saying, okay, this person does know who their family is. They do know they want to give X, Y, and Z to different family members. And then a trust which may be as simple as that, but may also have some other aspects to it. I mean, are there some guidelines that you can offer us that deal with that, the lines between those?
I'm going to defer that one first.
And probably an impossible question, but go ahead.
Well, it's not, but go ahead.
Yeah, I mean, Gosh, it's really challenging because testamentary capacity, as we know, is a very low bar. It's very simple, these three simple things. If the estate plan is also very, very simple, right? Like on par with what testamentary capacity consists of. Let's say all they have is a car and a house, and one beneficiary. There's not really a high level of complexity. I think when I'm looking at, trust or estate planning documents that do have this super high level of complexity, I don't feel that the testamentary bar and the bar required for that, the contractual bar in that case, are really connected. We do use medical records in some ways to help. Again, they can't directly tell us whether somebody had contractual capacity or not, but for example, filling out some really complex, end of life planning forms, or being able to engage in decision making around a really complicated medical decision of there's these risks and benefits, and if you do this, then this will happen, and if you do that, this will happen. And if the person can engage in that, can articulate their choice, can understand the risks and benefits, and engage in a discussion, that definitely has bearing on contractual capacity, maybe more than if they had testamentary capacity. So it's always on a case by case basis. There are obviously some connections, but it really is dependent on the individual situation. Dr.
Right.
Schrader.
And let me just say, I have testamentary capacity may not be as difficult, except sometimes I have more difficulty given the low standard for testamentary capacity, assessing whether that person truly has testamentary capacity when they don't know much. I mean, they might know family, they might know, what a will is, and the who would benefit, and obviously the simpler the situation, if a person has one asset, one family member, and knows what a will is, it can be quite simple, and they can be fairly demented. So to me, the greater it's someone who is below that bar is sometimes more difficult for me to assess. But the contractual ability, I think, is often easier if we can get the person to explain a little bit about what's happening. And of course, with testamentary capacity, I don't think there's no reasoning involved. So I go back to that word reasoning. If a person can reason and process information, yeah, they're more likely to have contractual capacity.
Let's go to the next slide. All right, so people use this term to a degree of medical certainty. Would either of you give an opinion that you did not have to a degree of medical certainty? Dr. Mourra?
Yeah.
Sorry, an opinion we did not have?
Right. I mean, is that basically anything either of you are going to say is always going to be with a degree of medical certainty, or what should lawyers know about that term?
I mean, yes, that's typically the standard that we use with regard to the opinions that we're issuing. If I have an opinion that does not rise to that level, then I'm definitely not going to be bringing that forward.
Or sometimes we can say, it appears that, or I believe that. I think to a degree of medical certainty, and that's certainly been debated among experts, what that means, what percentage that is, whether that's 50, 51, 49, or whatever it might be. But if I say it, it usually means I'm pretty certain about something. And if I don't say it could be, but I can't say for sure. Or I can't say for sure that this person has contractual capacity, then that means it's not to a degree of medical certainty. I'm not pretty clear about it.
So turning to the next bullet point about the Sanchez decision and its limits on what you can testify concerning as to the specific facts in that case, and whether there are those specific facts. and your reliance on medical records to provide those specific facts. Um, the This case that I've attached to your materials, the Gribben case, again goes through a useful analysis relating to how much of the medical records can actually be used for the foundation for an expert's opinion. Again, please don't cite this case. You can't cite it, but again, just in terms of reading it, I think it'll be useful. Because it is a probate case, it deals with setting aside some transfer on death deeds and goes through an appeal concerning the expert's reliance on medical records. Um, and One of the things that often comes up, obviously, is this hearsay? We have, we may have a business records custodian, or rather a custodian of records who can provide um, a basis for that the records could be business records. But again, looking at Evidence Code 1271, business records only applies to acts, conditions, or events that somebody put down in the course of their business duties, to summarize. So the question to the panelists here is, well, how do we deal with first a collateral witness? For example, let's just say the sister of the patient comes in and says to the doctor, well, my sister is um, um, didn't understand what she was doing when she came in. And then the medical provider puts that down in the notes. And then what's your feeling about whether you can use those to come to your opinion? Again, the sister is not there doing business. She's just stating what she's stating. Have you had experiences dealing with that issue in terms of the degree to which you can rely on that as part of your opinions? Is that
No, it's fair. I like the good old days before Sanchez. I'm sorry. It made it much easier. So yeah, I mean, no, given the example now, we shouldn't rely on what the sister said to the doctor, or even necessarily some of the things that the doctor may have written without getting the doctor's testimony or the sister's testimony. And that makes it'd be interesting to hear from the audience, but to me, that makes it more difficult on the lawyers involved to get this information admitted, because certainly in a retrospective review, we're relying on medical records. We're relying on descriptions from many different people. And so it'd be nice to have that information confirmed by somebody, post Sanchez. So our hands are tied in many ways.
Dr. Mourra?
Yeah, it's really interesting. I think Sanchez creates a bit of a shell shock for physicians moving into the forensic setting from the clinical setting, because as a physician, we actually, and especially a psychiatrist, we value collateral information like gold, right? Like, person comes into the ER, they're totally confused, they can't give us a story, and the family member or whoever's with them is able to frame it, is able to give us a sense of what was their baseline functioning, when did it change, et cetera, et cetera. So we are used to actually relying on those individuals and not doubting their intentions or their potential for coercion or manipulation. So it is a bit of a challenge. I think in this setting, it's a little different. I think Sanchez has sort of forced me to have a hierarchy within the medical note of the information that I value, or like the premium that I put on certain types of information. So if it's a nurse or a doctor observing behavior and making like an actual objective assessment within the hospital setting, that's obviously, I put that at a higher premium than, let's say, random neighbor who came in and is saying X, Y, and Z. But I also think, more neutral parties who accompany the individual who don't really have, a goal or skin in the game. And they're saying, oh, so and so has had 5 falls over the past week. And, they've been walking out into the street naked, trying to hail down police cars. That is a neutral party reporting that. I do think it should have some value, but obviously because of Sanchez, I have to be careful about how what I'm basing my opinion on.
Dr. Trader, what about the conclusions of a physician who's seeing the patient at the time? Again, under this Sanchez rule, it may be that a medical conclusion does not, or opinion may not be a description of an act, condition, or event, but be a professional opinion and may not be admissible. How do you, if you can, or had you had any experience where perhaps that doctor is not available, the lawyers have not been able to call him or her in for a deposition? They've moved, died. How do you deal with an opinion that's only as good as its foundation?
I think I probably had to deal with that 1 or 2 times since Sanchez, but we can still use our knowledge base as experts. I mean, that we can use, and to the extent we can tie that information, synthesize whatever observations that physician had to our knowledge base, perhaps you would allow it in. I'm not sure, but that's the only way I can see is to tie it into our fundamental knowledge.
Let's, in the interest of, since we're running out of time on here a little bit, jump to the breaking down undue influence slide, which is a couple of slides, Suzanne, down the road here. I'm going to skip over the definition of undue influence. There we go. Thank you. So let's talk about the third and fourth elements, because I think the first and second, susceptibility, the authority, I think most are less controversial, but the third element relating to actions and tactics. And again, the article I in your materials is excellent on this, but what's your views about opining on a third element, and then we'll talk about the fourth element in a minute. Dr. Mourra.
So, I mean, I typically take the position, and this was kind of how I was taught, and from the articles that I've read, kind of on my role in this regard. I often take the position that the third and fourth element are not within my expertise as a psychiatrist. So I'm happy to comment as a layperson about the third and fourth element, but it's not commenting within the scope of my expertise. So I typically do not, opine on those 2 aspects of undue influence. But I know everybody is a little bit different.
Dr. Trader.
So, I think in the article provided, the Plotkin Spar article, and it's true that as medical experts, especially psychiatrists, we're going to focus on item number 1, the vulnerability, and that's important. And I think 2 and 3 can be related, especially in terms of the third one, in terms of tactics. Usually there's some information on, let's say, a living situation. If one person is living with a supposed victim and is always occupying time, we know. But it always goes back to element number 1. How dependent is that person? And the more dependent that person is, the more vulnerable that person is, the more likely they are to be sort of influenced by a certain tactic. So I think we know about it, and we certainly know about the fourth element, about the equity. But so I think 2 and 3 are related somehow. I agree that number 1 is probably most important as far as what we can do, vulnerability.
What about giving an opinion that I've heard people try to do, of giving that there is or isn't undue influence? What do either of you do that, or what's your view about that?
I don't think you'll like that. I think that goes beyond using I think I've been asked that maybe once or twice in my career directly from a judge, but as an expert, we don't know all the facts, and so I now try to stay away from that absolute opinion, and we'll leave that up to the trier of fact.
I completely agree with that. I've been involved in cases where the attorney says they have an expert on the other side who's a psychologist or whoever, and they're opining that it happened, undue influence happened. So we want you to do that. And I have to say, I'm sorry, I don't do that. So
Well, let's being the devil's advocate here for a minute, and let's say a psychologist, as opposed to a psychiatrist, comes in who's got a substantial clinical experience, sees from a sort of non-medical perspective just what she's been, seen all kinds of cases over the years, and she may be able to, quote, aid the court based on that substantial clinical experience. Why wouldn't you want to go into things that might be common threads or red flags from a medical perspective that might be useful to the court in reaching its conclusion?
You could do that describing the vulnerability. You can do that describing a person's susceptibility to give the court information. But I still take the position, unless that person, and I don't think it has anything to do with the discipline of the examiner, but if that person had all the facts that, let's say, you from the bench or a jury has, maybe. But we never have all the facts.
Dr. Mourra?
I would agree with that.
So I think the article brings up a good point about that. It's hard enough to figure out the susceptibility or vulnerability of the person in question, but how are you going to know whether isn't it a danger for you to start opining about the motives of third persons? Is that something that you'd be in a position to give an opinion about?
Not unless that person's interviewed, but let's say if there's information, for example, that and it's credible information that the supposed influencer monitors the phones and doesn't tell the victim that so and so is called, locks the doors. There's certain information we would know about. I think that's important. But again, we generally don't know all the information.
I just wanted to bring up one legal point here in terms of the, quote, province of the court. This is sort of bandied about a bit, and experts naturally feel reluctant to want to invade, as it were. But I think it's important for everybody to look at section 805 and 801 of the evidence code, and that 805 changes the old rule that says that an expert's opinion is not admissible because it might invade the province of the court. In fact, going into the ultimate issue is okay under 805. The real issue is under 801 and whether the expert's opinion, quote, aids the court. Is what they're providing sufficiently beyond common experience, in the language of the statute, that they should be given, have an opportunity to provide that opinion to, quote, aid the court. So have you seen, in your experience, in different judges, I only get to be in my courtroom, you go to all of my colleagues' courtrooms, in terms of what aids one judge versus aids another judge? Have you seen judges take different positions about you're giving opinions on, for example, 3 and 4?
I can't say what the judges are thinking, but if I have some input on 3 and 4, I mean, usually on 4, I will always say, it's obvious, that one party benefited. That may be my standard line. But as far as element number 3, if I have some information about tactics and it's consistent with other documents, Yeah, I'll usually bring that out as part of the susceptibility.
Anything further, Dr. Moore, on that?
Um, I mean, I think I would. I've never been in a case where I definitively opined on the third and fourth element. So as to whether other judges have, used that in a different way, I can't really speak to it. I mean, I do know that in a lot of these cases, we don't only get medical records, but we sometimes get video footage of the influencer with the victim, or transcripts of recorded phone calls that people didn't realize their phone calls were being recorded. And we sometimes do get exposure to, the influencer was yelling and screaming at the person and threatening them that if they don't do X, Y, or Z, they're going to, stop operating their oxygen machine at night, things like that. So I think, it's a fine line. We can certainly, sometimes comment about like a red flag when faced with that sort of data in front of us. But in general, I would go with what Dr. Trader is sort of saying here.
We're sort of out of or beyond designated time, but if there are any final comments either of you want to share with in terms of giving advice to counsel about the other experts' report or anything, any final words?
My only advice is it's nice to have information well in advance. It's nice to have whatever issues we're asked to address. It's nice to have those issues spelled out so that we're pretty clear. And as Dr. Moore said, it's nice to have, as much of the information available as the attorneys, will allow.
I would agree with that. I mean, our ability to be of help to the attorney or to, provide opinions in the case is only going to be as good as the specificity of the question asked, as well as the data, that we are provided with. I mean, I think, in terms of other reports of other experts, present company not included, there's definitely looking at the sources of information like used by that individual can be very informative. Did they get the same stuff that I saw, or did they get more or less? I certainly also am very, I feel that experts that have no clinical experience or do not work clinically are sometimes, not getting the full picture in terms of, the individual that we're talking about. And so that is something that I also, assess and look at. But I would agree with what Dr. Trader said. I mean, getting all of the data in front of us is really very helpful and can help us be of best assistance to all the attorneys that are here.
And I would agree. So it also, the expert, sometimes primary physicians or other clinicians are used as experts who may not know or be able to tie in the standards for legal mental capacity decision making to the act in question, and sometimes that's obvious on reports. So I think to the extent that experts can be used who have an understanding of sort of the probate codes and then can tie that into the act may be more helpful to the attorney than just a primary physician who happens to be available.
Thank you both for all of your time, both today and in our last session. It's been a real pleasure working with you both. I hope this has been useful to all of those attending. And thank you everybody for attending. And again, take a look at those materials when you have time. And everybody have a good afternoon. And thank you very much. Take care.